We also did presidential motorcades, vice presidential motorcades, and many other dignitaries as well. So that's one side of it. That was the executive protection side. The other side, then kind of one that might be a little more applicable to the events that investigated with this was in charge of the state capitol security. So that included the House of Representatives and the Senate chambers. So dealing with those and then committee hearings as well. So there would be committee hearings over very contentious bills. We would have standards set in place ahead of time that were initially enforced by the sergeant at arms, which were not part of the state patrol. That was a legislative duty. The rules of order were set out. They were set out by the chair of the committee as well. And then they would be the ones to enforce and then ultimately determine if someone needed to be removed. So we dealt with multiple contentious ones. Vaccines were big ones. A bill called Right to Rest, which was a homeless subsidy bill. We had ones on state injection sites. So think of any controversial bill you could have in the legislature, and that's what we were in charge of dealing with in safety and security. So, and then additionally within the actual chambers of the Senate and House, again, it was the sergeant at arms that ran those. There were events such as the State of the State address, pretty much like the president gives the State of the Union, or the State of the State by the governor. We would be more in charge of the actual security of that event because our principle that we were protecting was in there as well. So with the coordination of the sergeant at arms. So during those times, we also had vocal protests, banner unfurlings, people gluing their hands together into the banisters. So having been in charge of those events and dealt with the way we handle those rules are a little bit different because they are very set out in the legislative body. So once it is in the legislative area, there's a lot more structure to it than say. But those are kind of the two varying aspects of that, and I did receive training on that. Went to First Amendment training on it. That was a week-long course, and there were multiple other things. And we would always do an after-action review as well, just to determine what we could do better, what went well, what didn't go well. I guess there is a third aspect. We dealt with protests as well. So anything that happens on the Capitol grounds, that was our duty to deal with. So that could go anything from we had 5,000 teachers come to the state capitol, which the building doesn't hold that many, but they were there, so dealing with all of those things. To high schools walking out of schools and coming down to protest for whatever issue was going on. There were protests on both the right and the left during COVID lockdowns, during the Black Lives Matter riots. So we dealt with a lot of those different things. The biggest thing we tried to do was communicate with people that were involved, communicate with leaders, and then also make clear expectations of conduct and what we were not going to tolerate.
So based on your training experience, when at a public event where there's disruptions, describe kind of the process that you specifically would take in dealing with those and how that your experience is done.
So there's two different ways that you would deal with those types of things. If I'm there on an executive protection side of things, I don't really care about somebody yelling and screaming. I'm going to keep their eye on them. I'm more worried if they're a threat to the actual person I'm there to protect. So I'm not going to jump into a crowd and deal with someone that's yelling and screaming. On the other side of it, such as large events or those committee hearings I talked about, again, there are specific rules that are set out in place in those committee hearings, which makes it very clear as when someone can and cannot talk or them be removed. But just in general, your biggest thing is the First Amendment allows anybody's voice to be heard. And so if there are
Going off of does the level of involvement in dealing in the security capacity for events that take place on public property, public entity, does the specific nature of that event dictate in any way how you respond?
To the relatives?
Well, it would be
that's in fact where we go, the objection will be overruled. If we stray more into an area of expert opinion, or into the different types of forums, and the result will go to attenuate the constitutional rights associated with a different forum, then likely to sustain an objection.
And so, we asked this question. Taking the experience that you had at capacity with executive security, Capital Grounds Security, Colorado, and adding to it the experience that you had in Idaho in the context of trespassing someone in a public event. How do you address those situations when they're not in, say, a legislative context or a city hall meeting type of context, when it's just more of a county?
So in those situations, so in just a public setting, there is a person in charge of either that event that's going on or the property themselves. If I show up being called to a disturbance as a radio control officer, I cannot walk in and determine that someone is trespassed on my home. The trespass authority has to come from those persons that are in charge of the event or those that are in charge of the property itself. So an example, real life example, not necessarily a public thing, but it's a public-private area. So I go to, I get called to a Wakita, and the person says that they don't want this person here anymore. They need them to leave. I go in and have a conversation with the person. I said, you need to leave. They're asking me to leave. I confirm with the person in charge that they want them to trespass. They confirm that and tell the person they are trespassed based upon their authority. I tell them they need to leave at that point. If they still choose not to leave, again, I ask them to leave again, explain to them that they will be arrested for trespassing if they don't leave at that time. If they still choose not to leave, then place them under arrest. And not until you've gone through those steps as to the explaining of who's trespassing them, that they need to leave, give them the opportunity to leave, and then place them under arrest if they choose not to leave. If they choose to leave on their own, they're arrested.
So is that the element of negotiation, voluntary compliance, de-escalation, if you will, is that important in those situations where trespass is being pursued by the property owner?
It's extremely important. There's no reason to push an issue if you're able to talk through it.
Is that true for just in general in your training and experience in law enforcement, any interaction with individuals that you face?
Yeah, so as a field training officer as well, I would train new police officers that they can either highly escalate a situation or de-escalate a situation just by the way that they talk to the person. So have I always been perfect? No, right? So I've escalated situations by the way I've talked about. I've always tried to learn those examples, and change the way that I've dealt with it. So it is in trainings that we go through, de-escalation trainings. Another one I've been through is called purple judo. Essentially, you got a lot of that training as a state trooper because often your closest backup was 20, 30 minutes away. So you have to be able to talk someone down and de-escalate someone. That is an individual response. It is very rare that in a situation, especially in a trespass situation, that I'm going to go hands-on with someone immediately after I have, before trying to do de-escalation or bargaining techniques.
Are there specific considerations of why we have to use force to remove someone from this property, pursuant to a trespass?
Yeah, so anytime you're going to use force, it needs to be reasonable. It needs to be, there are the opportunities that maybe force is warranted, but you don't need to because again, the de-escalation techniques that you're able to do. There are times when force is absolutely necessary, such as to prevent the further violence that's occurring, or there are just some of those instances where you have to take action. I mean, that there is a time for de-escalation. Most of the time, there's time for de-escalation prior to going on.
And in your experience with being part of multiple departments, each of those settings, is there a use of force policy that apply within the departments of?
Yes, there was.
And to your understanding, based on your training experience, that is a standard of any department of law enforcement agency that has use of force policy?
Yes, it is.
Shifting gears a little bit, so if you're presented with a situation where you have to arrest somebody, based on your training experience, what are the steps that you have to go through? Anything that you have to inform them of before you effect the arrest?
Ladies and gentlemen, we have some discussions we must have. We'll take a break from us. Please just remember, do not discuss this case among yourself or anyone else. Please do not hold a decision on the merits of the matter. It's been fully submitted to you for your information.
All rise.
All right, have a seat. You may be heard.
The totality of witness statements right now relating to department policy, procedures for how certain actions are conducted, trespass, de-escalation, all that would be applicable to a law enforcement officer, certainly. My client is not, nor does he work for a law enforcement department, or would he be subjected to any of those policies. What he would say is attempted to do is to question as to whether or not Sheriff Norris acted appropriately according to any policies that he may have or training that he should have or otherwise different ways that he should have acted. That is, in my opinion, an attempt to circumvent Your Honor's ruling as to whether or not a reasonableness standard applies to the conduct that my client engaged in when jury instruction explicitly requires only authority he had, not reasonableness, not training. So to go into the realm of whether or not Sheriff Norris had done something wrong or acted inappropriately or failed to comply with some policy, therefore negating his actions or the command that he gave my client is inappropriate. It's not relevant as to whether or not Sheriff Norris held that authority and whether or not he gave a command, which goes to all of it. There is not a count or an element of the count that would be affected in any of the jury instructions by question as to whether or not certain policies or procedures have been done properly, or whether or not Sheriff Norris acted in an appropriate way pursuant to law enforcement policy.
Mr. Anders, isn't it implied in the jury instructions that were crafted here in terms of the performance of the sheriff's duties, that those duties must be performed lawfully? The lawful duties of the sheriff.
You're right, yes, Your Honor. The sheriff's duties, they have to be pursuant to his authority. Now, the question of whether or not he acted well with that authority is not the same thing with whether Bushnell the authority to trespass somebody. That's not what the statute relative to my client says. It doesn't say if the officer acted well within his authority, or if he was lawfully giving a trespass order, it's whether or not he had the authority to do so. And that's a question of law, not a question of fact. And as it pertains to my client, merely whether or not the sheriff possessed that authority, not whether or not he was using it well. And I would harken back to the omnibus hearing. We're talking about that umbrella protection, it only taking place, the question of reasonableness only being addressed if it's first established as a ruling law that the individual was acting outside of their authority as law enforcement. And so to bring up all of these questions, when Sheriff Norris is not the one that's on trial here, I don't have to defend Sheriff Norris's actions. I merely, the state has to receive the burden of proving that Sheriff Norris did not have the authority, not that he didn't act well within it, but that he didn't possess the authority. Whether or not he possessed it and used it well is two separate questions. And I think that this line of questioning goes into why you need that question.
Thank you, Mr. Kenner. Any response, Mr. Lecter?
Yes, sir. So a couple of things, and just kind of dovetailing off of the last point the council made is, it's not simply whether the sheriff has the authority, because that's an alternate matter. He has the authority to arrest. You know, the statute tells us he has that authority. The question is, as far as what jury instruction for the affirmative defense provides, is using that authority. Now, the instruction does not advise or require the jury to consider whether he was using law, as counsel said, but I think they still must find that he was engaged in one of the authorized duties that he has. And I think the consideration, if the jury chooses to make it, whether he was lawful, whether it was a legitimate, a viable, a legal use of that authority in that circumstance is appropriate. Jury instruction certainly does not prohibit that. And I think it can be reasonably gleaned from the language of the instruction itself, as well as the statutes that it's based on, that if he was inappropriately exercising his arrest authority, he being Sheriff Norris, if he's failing to follow any of the standard procedures for effecting an arrest, failing to tell anyone that they're arrested, failing to tell anyone that they are, or what they're being arrested for, then it is reasonable to then presume that he's not actually engaged in the lawful or really any exercise of his arrest authority in that circumstance. There's three different bases that the state has to overcome, and prove beyond reasonable doubt does not apply if the court ultimately decides to give the jury instruction for defense. The other one was suppressing breaches of the peace, a phrase, riots, insurrections, that sort of thing. And Chief Haley is testified as to considerations that go into that, sort of tangentially, but bring it back around in terms of what that implies. And then there's the final point, the final authority that the sheriff has, which is to preserve the peace. So it's an undefined term. What that means, I think, is going to be subject to probably this argument. And what Chief Haley has been testifying to, again, goes directly to what that means in the law enforcement context, which is relevant to whether the sheriff is actually engaged in that law, that duty that he has. And so, talking about what the normal, based on his training and experience, what goes into an arrest, what's required under Idaho law, based on his training and experience, is relevant to that question, which is determined as an authorized use. Was it in any way an actual legitimate use of the arrest authority, the arrest duty that the sheriff has? You can't just arrest anybody for no reason whatsoever. He's still required to comply with the law. When doing so, it's appropriate for the jury to consider whether that was applicable when that was happening. And setting that aside, even once that's set aside, then we still have the defendant's own conduct. He's still subject to requirements for arrest. If he is effecting an arrest, he has to comply with the statute that apply for things that we're trying to juggle here, both preemptively responding to the affirmative defense, but also going directly to what the defendant himself did in this capacity of the security issue. That's where I think this also is relevant, but it's starting to what the state has to prove.
Yes, sir.
The dynamic that the city just laid out is exactly contrary to the entire discussion that was had and before your honor's ruling as to whether or not there would be a reasonableness element in that jury instruction. If an individual is commanded by law enforcement to act in the moment, because the law could subject them to criminal liability prior to acting, they have to run through an analysis about whether or not this officer is lawful, whether you simply wouldn't know. If you walk onto a scenario where an officer is rolling on the ground with somebody, you have no idea whether or not that officer initiated a lawful arrest or whether they had the lawful authority to trespass a person. If that officer demands or requests your assistance and you help the officer, that's the exact public policy point as to why this justification exists, that when you're commanded by law enforcement, you don't have to do that analysis. You don't have to be an expert in the law. You don't have to know the nuances of trespass law or the nuances of citizens arrest law in order to assist the law enforcement officer. You're allowed to rely on the officer and their authority as an officer in order to act. And I think that's what's getting muddied up here. The discussion, the statements by the state effectively create a new reasonableness requirement that is simply not contained in any of the jury instructions, such that the jury would have to decide whether or not the sheriff was acting reasonably, whether he reasonably gave commands, whether or not it was reasonable that the client listened to those commands. All of those reasonableness standards are not contained in the jury instructions and are argued specifically against them by this jury instruction.
Well, I see these as two separate and distinct issues. The reasonableness standard, which we've discussed, and the court specifically found that the reasonableness standard would not be appropriate to include in the affirmative defense, essentially elements instruction as it relates to the offenses of battery and false imprisonment. However, the discussion on whether a duty is lawful or not doesn't relate specifically to the affirmative defense instruction, rather to the definition instruction of the required duties of the sheriff. And implicit, so taking the discussion of reasonableness off the table, because that's not included in any of the proposed or any of the affirmative defense jury instructions here. What we're talking about here is whether or not the duty exercised by the sheriff must be lawful. And that's implicit in this instruction. If the jury was to find that the sheriff was not exercising his duty, they would, by virtue of finding that the duty was not exercised, that it was not lawful. And so the question for the court, however, is whether this witness's testimony as it relates to the standard procedures vis-a-vis an arrest with by the Coeur d'Alene police is commensurate or somehow can be then used to demonstrate, well, these procedures are practiced by the Coeur d'Alene police and they should have been practiced by the sheriff in exercising any arrest. And in as much as that may be relevant, relevancy is a pretty low standard. And so what the Coeur d'Alene Police Department does in terms of their standard operating procedures with arrests would be relevant in the sense that it does touch on questions here, and specifically addresses one of the duties articulated in the affirmative defense instruction, and that is that the sheriff is required to arrest persons who attempt to commit or have committed a public offense. So it is relevant in that respect and is touched upon by the instruction. And so it overruled the objection, understanding that how much we get into these policies and procedures may strain into irrelevant. But for the purposes of this explanation and this witness being able to testify about those arrest procedures, is marginally relevant. And so
informing the person of your lawful authority to do so, to arrest them, what they are being arrested for, and what the actions were that those. So those are the main things that they should be being told. So, such as that, the example I gave you, I was told the person, obviously I would be in uniform with them, and they're acting as a police officer, so I may not say the words "orderly police officer," but you're under arrest for trespassing because you're not leaving me for trespassing. Something like that.
Is it something that you trained on at a post?
That, for myself, it was during my field training, and what we call the pre-phase, basically some training I did before I jumped into a patrol car. That was part of that transition to the Idaho code still that as well.
Was that part of the, what you had to complete your training? When you're going to Colorado post?
It wasn't as specific as far as the law was concerned with Colorado, but you still have the when can you arrest, what should you say, those types of things. I believe I first learned about it when Chief White, Lee White, Portland came in and spoke about use of force. So he came in and spoke with us officers on the first and second day that we were there, so that we would hear about use of force from him. One of those key things was if you're going to use force, let them know if they're under arrest or like doing it or prior to doing it. Set that stage for them.
Now, pursuant to your position formerly with the Coeur d'Alene Police Department, you have to be familiar with the various aspects of the Coeur d'Alene City Code, what was required, what was violation of law within the Coeur d'Alene City Code.
Yes, we did.
How do you shrink from that clear space? If I Chief Haley, I'm handing you States Exhibit 9, which is a certified copy of Portland City Code, Chapter 5132. Take a look through that. During your time with the Portland Police Department, as part of this investigation, you have become familiar with the contents of what's required.
Yes, I did.
And so, based on what's contained in that code, what requirements are there for the security agency to be able to operate that are relevant to this case during your investigation?
That was relevant specifically for this case is they need to have a contract, and they need to have that contract with them at all times when they are acting in that security function, and all members must have that contract on them. The other piece of it is specifically the identification. Make sure I get this part right. The badge, uniform, and vehicles, it specifically speaks about they must be clearly marked with the word security and letters no less than 1 inch tall in the front of the uniform and no less than 4 inches tall in the back of the uniform.
Hold that there, any additional questions here. Now, we've talked a little bit about this thing a few times, but I want to direct your attention back to the background for the investigation that you did while you were simply as a detective. You signed to investigate the incident at Portland High School that occurred on February 22nd.
Yes, I was.
And we'll just describe how you were assigned to that case and your understanding of what the nature of it is.
So initially, I had what had occurred in the news and on Facebook, just like many people had. Based upon my training and experience that you have all heard, I felt I was uniquely qualified to look into what had occurred at that event. So I actually let my supervisors know that I was willing to do that because I knew it was going to be a bullet in the charge. Not every detective was interested in that. So I offered to do the investigation on the case. And at the beginning of gathering information, and was just told to let the investigation go where it leads. There was no specific outcome requested. There was no direction given other than let us know what assistance you need and what resources you need to get this investigation done.
And so once you were assigned that case after 12 years, explain kind of the first steps that you took to start investigating what had occurred in the last event.
First of all, was just get a handle on what I was dealing with. So I began doing open source research and pulling videos down, downloading them off the internet so that way I have them preserved. I started receiving phone calls about people wanting to offer videos, so I continued to collect those and then just started cataloging them as they would come in. That was the initial piece of what I did was just truly trying to get a grasp on what had occurred during that time, as far as the generalization of it, and where should I be looking for further evidence. It's just kind of mapping out the investigation.
Were you able to find a lot of publicly posted videos about this?
There was quite a few publicly posted videos. Additionally, I spoke with, by watching some of those videos, I was able to determine whose cell phone that Sheriff Norris was utilizing to videotape. It turned out to be one of the security officers, Jesse Jones. Contacted him and he provided me with those videos early on in the investigation.
Prime time to play that video. CDA States Exhibit 7. Please.
Mr. Hunter, how long is this video?
This one is too long. Double check the length of it here.
Thank you.
Permission to publish States Exhibit 27.
Okay.
Exhibit 27 shall be published.
What I'm doing up here is I'm simply over talking you because your voice is meaningless right now. And we're just taking care of the medical business. And eventually what's going to happen is everything's going to settle down and we'll get back to here to the legislators. Because really, you didn't come here to listen to me. I just happen to have a nice loud voice and a big microphone. And I can talk over all of you. And I can just talk for on and on and on. And look at this little girl is afraid to leave. She spoke up, and now she doesn't want to suffer consequences. Isn't that the problem? We're struggling with so many of the kids today, is they want to be great. Well, Steve, she's holding in her house. She's got to be good too. That is just shameful. I think what we've got right now is a situation where these folks are trying to filibuster and shut this whole program down. Unfortunately, they're being successful. I got zip ties. You got cuffs on you?
No.
Turn around. Put your hand behind your back.
Get your box to me.
Spread your feet. Spread your feet. Spread your
That's
feet.
as far as they go.
Do not move. You understand me?
I'm not moving.
Okay, do not move.
Some people talk. Gross. Gross. Shame on you all.
I'm gonna call some deputies. Hey, I got you. I need those.
I don't have any.
I got them. I'll give you an hour.
What an idiot. Obama.
Pause this. Take everybody behind the curtain. Pause.
Not the animal guard. You're interrupting when somebody's speaking. That's what your problem is. I said you should get it off your serious over behind your feet. And you're gonna tell me to get it off moving.
There's no public comment.
There's not the public comment. But why are you here? Why are you here? All you're here to do is to disrupt. Hey, get out of the way. Get out of the way.
Hey, Ed. I need 2 more security officers, please. Need 2 more security officers in the back. Paul. Need 2 more security officers back stage right. Ladies and gentlemen, as soon as we get things under control, we will get back to hearing from the legislators.
Can I say something?
Yes.
As an American citizen that wanted to hear this, and I'm on the opposite side, I want to say that this man has been very rude today. Wait, I'm talking about this guy at the podium. I want to say that I felt like if you're on this side, you get to have a voice, but on the other side, you don't get a voice.
I think it's a matter of behavior.
I know this probably wouldn't do this, but I would love it if you would listen to so that it's clear that anybody can do this. I know any side of the coin.
Thank you.
watching that, true and accurate representation of the video received from Judge Jones.
Yes.
Or on the cell phone.
That is correct.
So a couple of questions shown there. Just clarify the jury for the record. So at the beginning it shows individual Sheriff Norris, the one speaking to the woman. And who's the woman in the purple coat that you can please on which you found during your investigation?
Yeah, to the left of, oh, the race war.
And there's an individual that, man, wearing black sweaters, swords, and taking very long. What's your investigation?
Yeah, it took a little bit until he came forward and identified himself.
Just based on reviewing this video, as part of your investigation, what any potential criminal offenses did you see shown in this video?
So the criminal offenses I started investigating and that I was putting on my search warrants when I requested things, was initially investigating battery, false imprisonment, and then potential kidnapping as per the actual code. When you think of kidnapping, it's not like taking a kid and putting him, it's not just a kid, it's just forcefully moving someone. So those were the crimes that I was initially looking at based upon my first blush at the video.
So far as you can tell, just from this first several videos that you reviewed, was it readily apparent why Stormbolt was being forcibly removed?
Not on this video.
Based on what's depicted in this video, was it readily apparent why Raver Johnson was forced to leave?
No.
Were you able to identify who the other woman who was shown towards the tail end of that video, that shows you the recording for that last portion of the video?
Identified one of them, Lord.
Again, it's readily apparent from what was depicted in this video why the sheriff was reporting that time.
At the beginning, he had pointed to Laura as well. It stated, I believe, she's holding on to her, but Laura was holding her phone in her right hand, which is closest to Teresa. And then she was also told that she was out as well. So, and then the sheriff states, I need 2 more security officers. I believe he was speaking about those 2 individuals that he was looking to still have.
So as part of your investigation with this video and with any of the other videos that you were able to gather, explain just for the jury's information process, how you go about saving those, I guess, retaining those for later use.
Certainly. Coeur d'Alene has its own specific evidence, digital evidence saving program called Viper. Can't remember what it stands for, we built it in-house. And so I would, initially when I was gathering videos, I put them into a folder on the work computer desktop and then kept a running list of what the videos were. I know, I did that because I know if I just start uploading video after video to the Viper storage, it's harder to look at it and then have a, find which video I'm looking for. So if I put them in a folder, it's much easier to upload them that way. So I numbered each video, where they came from, what they were, and then eventually I zipped that folder and then uploaded it to our digital evidence storage Viper. So essentially it is housed on a server, a secure server at that point.
And that secure server, the videos, once they're uploaded, are able to be manipulated or modified within that system.
No, the videos cannot be.
So I think you described pulling some videos off of social media and getting the cell phone video for
Yes, there's a search warrant.
And let's briefly about what you were able to obtain in that search warrant. Describe what the process of getting the search warrant for originally.
So I had contacted first KCRCC's chair, Brent Regan, and asked them if there was any video within or that they have that they could provide to me of the entire event. Stated that there was no official videographer, but that he would find out. And so, and again, I got an email from him less than a week, approximately a week later, basically saying that some of the video files of what had occurred with Racer were corrupted, but there was stuff from after it had occurred. That the videographer was still trying to recover that data, but had been unsuccessful at that point. I had determined through investigation that the videographer was Jeremy, I don't know, it's Locken or Logan, and he was the videographer during that time. So I went to his residence within Court Lane, ended up speaking with him and explaining that I would like to see the video so I can conduct a holistic investigation, and that I was aware that he was the one that had the videos. He stated that he would put them onto a thumb drive for me, that he would work on that throughout that day, be in contact with the afternoon of the day that I spoke with him.
And did you subsequently get contact with him?
No, he did not. So I gave him about an extra hour from when we were supposed to talk. I called him several times, went back to his residence that he shared with his parents. I spoke with them. They stated that he would be home soon. They had just spoken on the phone and that he was in the process of trying to transfer the videos for me. I waited about 45 minutes. During that time frame, I waited just in my vehicle outside the residence. During that time frame, I received a phone call from someone who identified themselves as a reporter with the Trouette Journal, asking me why I was trying to obtain a private citizen's property without a warrant. I don't give out my work cell phone very often, but I had been utilizing it to call Jeremy. And so then, based on that, I came to the assumption that he was not calling me back. He had provided my information to a reporter, and speculation.
And so, based on that, what did you do next?
So I went back to the office, typed up a search warrant for the residence, for the video, for all of the video with regards to the town hall event. And then it was signed by a judge, and then myself and fellow detectives and the sergeant went and executed the search warrant for the residence.
And on execution of that warrant, you obtained several video files from Mr. Long's computer systems.
Yes, so the transferring was being difficult. Initially, he was going to provide me, I think, 3 or 4 videos. Turned out as we worked through the footage, it was more than, it was at least 13 approximately videos that contained footage of what had occurred. There were 2 camera views from the back and 1 from the stage. We ended up, so we were going to sit there all night, taking up his time at his residence. I took he provided me the drive that they were on. Several officers stayed at the residence. I went back to the police department, transferred those to a computer, verified that they were the files that they were supposed to be, and then transferred them to a hard drive and later into evidence, and then returned that drive to Jeremy later that night.
And did you review those video files as part of that investigation?
Yes, I did.
What kind of things did they show?
So there was, essentially there's 2 main aisles in the middle of the auditorium, and then there was cameras set up on either one, and then there was a stage camera set up on, it would be, as you're facing the stage, it's on the left, which is where the speaker podium was. And that camera was on a small tripod, with one from the back or on the larger one. There were also times where Jeremy would take the camera off of the tripod on the left side, as you're facing, and then utilize it so they could get closer shots.
In the files that were recovered, you previously
submittal for evidence today?
Yes.
Yes, I did.
And, just to clarify which one, so which, so it's a 23C, is that, crowd camera raw, redacted versions of that?
Correct.
It says the 24B, is that the redacted portions of file C0147, continuation of that same crowd facing camera?
Yes, that was what was on the list.
It's marked 25B, that is a redacted portion of the video file of clip 2071.
Yes.
And what do you recall, what that is when that clip 2071 video showed?
Trying to recall which one. It would have been from the back. I've looked through so many videos, so it was, I would have to
Either the left or the
view
right.
it again to see the left or the right, from the back portion. So you have the upper stadium portion of the auditorium, then you have the lower part of the slope that was in on the walkway in between places where those were both stationed.
And then 26C, the redacted version of the other camera's video file, whichever one that I gave, titled C0149. Is that correct?
That is correct.
So did you add your initials to each of those files onto the,
I did.
or, sorry, excuse me, each of those disks?
Yes, I did.
And those are back portions, those are still true and accurate representations of the word, they can show separate videos.
Yes, they are.
This time around, I think most efficient to publish one of those videos, the others will address it tomorrow. But states it to 25, or excuse me, 23C is the portions of the crowd camera raw. It's about 15 minutes, no more than 15 minutes. That's right.
Let's leave that for tomorrow. My preference would be not to, push us past 5. That holds a lot of people up. So if we're going past 5 today. I made the promise we'd be done before 5, we're at 5. And I'm a little worried if we play the video, it's more than 15 minutes, I might put it past 5 and cause issues. So, take a break today for a second.
And logistically, and for the council on this, somewhat of a legal process, that's all the questions we have for technicalities at this juncture. I'll have more for it a little bit later on. We anticipate meeting tomorrow, additional witness testimony, with that. Preferably need to have all this cross-examination, technically, all of us, completely understand that, so.
Are you okay with that, Mr. Hernandez?
Yes, Your Honor, I'm good with that.
Okay. And so what we'll anticipate for tomorrow is, technically, he'll be back with, back at council table. We'll watch just one video then at the start of tomorrow, or?
I think, probably one, maybe two, the total, a little more than a half hour, to kick off tomorrow. And then, after that, we'll just be graceful.
Okay. And so that also means that we'll watch a couple of videos first thing, but we're going to take witnesses out of order. Normally, obviously after direct examination of Chief Haley, Mr. Tanner's going to have the opportunity to ask questions as well. But I know you told the lawyers would like to take the witnesses a bit out of order, and so you may hear from a different witness a bit out of order, and then Chief Haley will come back to the stand, and then have an opportunity to cross-examine or raise further questions from Mr. Tanner tomorrow. That's how we'll proceed tomorrow. I have to give you, not the short form of my admonition, but the long form. You are are instructed you're not to discuss this case amongst yourselves or with anyone else, including any use of email, text messaging, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct